So the purpose of this presentation is to give you all a feel for some critical construction contract provisions in your subcontracts and what you need to know to best protect your rights and your bottom line. And so we're going to start off, we've broken this down into 3 parts. I'll do the first part, first few slides. The first slide that we have here is the contract documents, and that's pretty basic. First thing, obviously, read your subcontract. We see lots of times where folks have not read their subcontract, and sometimes it's not even signed by all the parties. So get that step out of the way, make sure you understand before you sign the contract what you're actually getting into, and then assuming that you agree to the terms, make sure that everybody has signed it. You want to also not stop there. Don't just put it on the shelf and get to it if there is a dispute or something goes wrong on the project. Review it periodically during the project, maybe even create some sort of memorandum or notes on the key contract provisions and circulate it to your team. Also need to know what types of documents are part of your subcontract. We've seen many instances where there is a subcontract, we get a copy of the subcontract, but there are documents referenced in it and incorporated into it, and we don't, the parties don't have all of those documents. So just make sure that you know what documents are included in your subcontract and that you have copies of all of those. For those of you who are subcontractors on this webinar, you'll probably see, or you've seen, contracts that incorporate the prime contract. And that's the contract between the owner and the general contractor. And so to the extent your subcontract incorporates that document, you want to make sure that you get a copy of that, review it, and try to avoid any ambiguities between the prime contract and your subcontract. Another thing to keep in mind in understanding what the contract documents are or is making sure that you understand what the order of precedence will be as it relates to those documents. And the order of precedence is simply a fancy term that means what contract document is going to control in the event that there is a conflict or ambiguity. So if you're dealing with a bunch of contract documents, just make sure somewhere in the contract it spells out which document is going to control over the others. This is just an example from an AIA contract of the definition of the subcontract documents, and you'll see there that the first line that it references that prime contract as part of the subcontract agreement here. So again, can't overemphasize the importance of getting a copy of the prime contract to the extent that it's incorporated into your subcontract to make sure you understand all of the implications of that being incorporated into your contract. For example, there can be flow down provisions, pass-through provisions that basically say the subcontractor gets what the general contractor gets, no more, no less, things of that nature. You want to make sure you are aware of those things before you sign on the dotted line. Scope of work. This is the most basic and perhaps the most important of the provisions in a subcontract or any construction contract for that matter. And as the slide indicates, it forms the basis of your performance. You want to make sure that the contract that you're signing is as clear as possible and spells out exactly what you're going to do. Consider an addendum to your contract, an exhibit to your contract that clearly spells out what the scope is going to be, and make sure that you understand what the specifications are going to be that are implicated in your work, and to the extent that there are specifications referenced in your subcontract that implicate other trades or not even the work that you're doing, you want to make sure that those are excluded from your subcontract, so there's no argument that those specifications, though in your mind were not part of the scope, the prime contractor believes were. So be real clear on that. Specify what you're going to do. Don't leave any gaps. The gaps are where we see litigation ensue, and so do your best to be clear on the scope and also include a list of any exclusions. Make sure that your subcontract spells that out in terms of the exclusions. You don't want to rely on a proposal perhaps that you've provided in advance of the signing of the subcontract, because odds are there's the proposal is not going to be part of the subcontract. It's going to be something outside of the contract. So any exclusions you want to make sure are captured in the actual subcontract or an addendum to it. These are some traps to avoid in terms of your scope of work on any particular subcontract. Avoid the fancy terms like reasonably inferable from the plans and specifications, or in strict accordance, or the highest degree of skill. Those are all things that owners and general contractors like to slip into agreements, but do your best to try to carve those things out, because that just allows for someone on the other side to argue that you should have known essentially that the work, although not particularly articulated or specifically articulated in your subcontract, you should have known that that was part of your work, and therefore if you don't do it, there's going to be a problem, and if you haven't priced it, they're going to look to you to incur that cost to complete that scope. Again, back to the order of precedence, you want to make sure that the terms of your subcontract govern in the event that there is an inconsistency with any of the contract documents. Going back to the point that I made on your proposal, we'll see merger and integration provisions in subcontracts, which is a fancy term of art that basically says that any other agreements that you had before this subcontract are no longer of any consequence. So if you want a document that you have executed or agreed to with the general contractor to actually be a subcontract document, make sure that it is part of that subcontract, because if you have the merger and integration provisions, it's going to be that prior document is not going to have any effect. Again, with the project specifications, make sure that those are consistent with your scope of work. Read those specifications that are referenced in your subcontract before you sign it to make sure that they are married up with what you believe is the scope of work. This is a sample provision from the AIA contract documents. Again, pretty basic stuff, but couple things that wanted to bring to your attention. So this section references a document, the drawings and specifications that you're going to be tied to, as well as addenda, things of that nature. So make sure that, again, a precise description of the work needs to be a critical focus for you when you're putting together these subcontract agreements, so everybody knows what the scope is. Refer to the particular drawings, refer to the exact specifications section so there isn't any dispute. Payment, another really important component of a subcontract, and obviously one that you all want to make sure you get right and you get paid for the work that you're doing. So contracts will have language in them, of course, that talk about the basis for of payment, schedule of values, things like that, cost plus, lump sum, time and materials, all those types of payment terms. We all know about progress and partial payments. Those are what payments are made during the course of the project and leading up to the final payment. And then finally, what can you as a subcontractor do to leverage, make sure that you do get paid? And is that the ability to suspend your work on the project? Is that the ability to terminate your work on the project? Both scenarios should be incorporated into your subcontract, so you're not waiting around and hoping that someone's going to pay you with a requirement that you continue to perform while you're waiting. So some payment do's and don'ts. So do include in your subcontract procedural and documentary requirements for payment. You want to make sure that vis-a-vis the general contractor that it's specified exactly what you need to provide in order to be paid. We see contracts, subcontracts that have have some documentary requirements, and then there is some language in the subcontract which gives the general contractor some additional discretion, and it says whatever else the general contractor may reasonably require. We suggest that you spell out all of the requirements, and that way there's no argument about you not providing some sort of documentation that wasn't listed but that the general contractor believes is necessary. Again, if your contract is incorporating the prime contract, make sure you understand what the prime contract payment requirements are. The timing of the general contractor's pay applications, the bond and lien waivers that have to be provided by you and your subs and your suppliers. Also, as I mentioned earlier, make sure you have, if you can, the ability to suspend or terminate your work if you're not paid. That seems basic, but many contracts that we look at don't account for that. And you definitely want to have the ability to, after a certain period of time, if you're not paid, to take those actions. Also, make sure that your subcontract addresses retainage. Is that going to be held at a fixed percent throughout the course of the project? Is that going to be reduced to zero at substantial completion or 50% completion? Obviously, you want the vis-a-vis the general contractor paying you, you want your retainage to be reduced as much as possible at a certain point during the project. So pay attention to that. Some don'ts regarding payment. If you can avoid it, and we understand that it's not always a negotiable proposition when it comes to these payment terms and some of these other provisions that we're talking about here, but to the extent you can, try to excise any sort of pay if paid provision from your contract. Many of you on the webinar are aware of these types of provisions, but it's basically a risk shifting mechanism that the general contractor can use that basically says, hey, if I'm not paid by the owner, then I don't have an obligation to pay you, Mr. and Mrs. Subcontractor. So, and that can put you in a precarious position. So try to avoid using or agreeing to those types of provisions. Again, don't agree to continue to perform work if you've not been paid. Factor in a suspension or termination provision after a certain period of time to best protect yourself there. And don't allow the general contractor too much discretion to determine whether or not to pay you. It should be very clear-cut in terms of the timing of your pay application, the documents that you're required to provide in order for you to get paid. This last set of slides deals with extra work and what we can do to best protect ourselves to get paid for that work or get additional time for that work. Most of you probably know change orders and change directives. Those are legal terms that basically allow for the general contractor or the owner, depending on what relationship you have, to order additional work to be done by the subcontractor. The change orders will come from the general contractor vis-a-vis the subcontractor, of course, and same with the change directives. But these are mini contracts. And a lot of people don't appreciate the fact that these can change the contract. They can have drastic results if you don't pay close attention to what exactly the change orders say. They can be in writing. Typically, good contracts will require them to be in writing, but certainly there are instances where there are oral change orders, and depending on the situation, those can be enforceable. Depending on how the parties have operated during the course of the project. But the extra work component of a change order should address the additional time that it will take to complete the work, as well as, of course, the additional cost to the subcontractor for performing it. A couple things to keep in mind about change orders. We want to make sure in looking at the subcontract that you understand who has the ability to sign them. A good subcontract will spell out who from the general contractor has the authority to sign them, and same thing for the subcontractor. So there isn't a argument that so-and-so didn't have the ability or the authority to agree to that extra work. Certainly, when it comes to change orders, the parties can change what's in the contract, even if in the subcontract, even if it says they can't. emails and things like that, requesting additional work can serve as a change order. So be on the lookout for those types of written communications which may alter the party's rights vis-a-vis extra work. Last slide here on extra work, do's and don'ts. So best practice requires sign change orders prior to performing your extra work. That's the best practice. I realize that it doesn't always work that way in the field. Things get hurried and rushed, and we'll get a signed change order later. Do your best to get the change order signed by both parties. Follow the subcontract provisions on what's required there to avoid any disputes down the road. Identify in your subcontract how those change orders are going to be priced. Don't leave it open to interpretation, reasonable costs, things like that. Do your best to be specific there. Again, identify who's authorized to sign them. Include the ability to seek additional time, not just extra money for that extra work. Lastly, in terms of the don'ts related to extra work and change orders, do not sign change orders without reading them. It sounds very basic and somewhat silly to even say that, but it happens. And as I mentioned earlier, there are many contracts and they may contain some gotchas, including a waiver and release of any pending claims that you may have leading up to that point. We've seen change orders that people sign where it agrees that they're waiving and releasing any claims leading up to that date. Well, there's hundreds of $1,000s of claims that have not been resolved that prior to that change order had been reserved, but now we've got a change order from somebody saying that they've released it. That becomes an issue. Try your best to not agree to any flow down or pass through provisions from the prime contract. I get it; those are oftentimes difficult to negotiate out of your contract, but you'd like your subcontract to stand on its own and not have to deal with the requirements that the owner is putting on the GC. I get it; that's not always feasible, but if you don't ask, you don't get. So we suggest that you try to extricate those types of provisions to the extent you can. Also, don't include any sort of cap on the amount to be paid for change order work. The change order work is going to be what it costs you overhead and profit. So be aware of those types of provisions in your subcontract. With that, I'll turn it over to Austin Calhoun. Oh, we got one more slide here. Sorry, this is the change order directive slide from the AIA contract provision. This is not a change order where both parties sign, but where the contractor orders the subcontractor to perform the work without invalidating the contract. So just make sure that you understand that there is the ability for the contractor to do that without a fully executed change order, but try to be as specific as you can in terms of how that work is going to be priced and how you'll be paid for it.
Thank you, Joby. This is Austin, and we're moving on to a topic that's really relevant to today's marketplace in particular. I don't need to tell you how construction prices have been skyrocketing and are predicted to continue. We've had a lot of calls from our subcontractor clients asking us, how do they deal with the price increases both on material and labor when they're in a fixed contract. Well, that depends on your contract terms, but we have some other ideas as well. And in the next couple of slides, we'll look at contract terms in a fixed price contract and what you can do when you're stuck in a fixed price contract. But there are other things to consider first. You can shift responsibility for purchasing the materials to either the owner or the GC. Do a labor-only subcontract. Then you're not at risk for the material prices going up. Have the owner or the GC direct purchase the materials. Again, so you're not at risk for those price increases. If you are at risk for the price increases, try to procure your materials early and get them stored on site early. Talk about that with the owner and the general contractor. Let them know that prices are predicted to go up, and in order to lock down those prices at current prices, you need to buy them now, and you need somewhere to store them now. So that's a good practice pointer if it's feasible for your project. Last, consider a cost plus delivery method. I know many GCs don't find that palatable. They require you to be in a fixed price contract, but today's marketplace that delivery method can be a little bit more fluid. You may have more negotiation power to change your delivery method. A couple of practice pointers and project management tips. We talked about procuring your materials early, but if you're subbing out any of your work to a sub, if you're subbing out to a labor, buy it out early. And by buy it out, I mean lock your sub into a signed subcontract at the very beginning of the job. Don't wait until the phase of the project where that work is going to commence. If you're in a 2-year-long project, you get awarded your subcontract near the beginning of the project, but you're not set to start for about a year. Well, within a year, labor prices, material prices could go up substantially. So lock those down by executing your subcontracts and purchase orders early. Another practice pointer, in your proposals, today more than ever, it's important to include an expiration date. Your proposal is only good for 30 days or however long you're able to lock in your prices. Another tip on your proposals is state on the proposal your anticipated work dates. This price is good if our work is performed during this period of time, starting on this date. And that way, if the overall project start or during the project it gets delayed and it pushes you back, you've got a better argument that any cost increases during that interim, you should not suffer. Okay, let's talk about fixed price contracts, which I'm sure many of you are familiar with and have to operate under. What can you do in those? Try to get a price escalation clause. Ideally, that would be open-ended, and that would allow you to recover from the general contractor any additional cost, any increases that are unanticipated for your materials and labor. Open-ended is going to be really hard to get, I understand. There may be a compromise to include a trigger that your price escalation clause is only triggered in the event the prices go up by a certain amount. And on the next slide, we'll look at a sample provision. Another idea is an escape clause. And what does that mean? That's where if prices skyrocket and get so extremely high that you no longer want to be, have a contract for that project, that you want to terminate your contract and get out, they allow you to do so. It's a type of termination for convenience provision, but it spells out that you can only terminate for convenience in the event that prices get too high, and you would need to spell out what that means. Is that your material prices increase by 50%, and if so, you can terminate. In today's market, it's good to refresh on the ramifications of a termination for convenience, because we predict that we'll be seeing more of that, and general contractors are often going to have the ability in your subcontract to terminate you for the GC's convenience. And if they do, And that may be because the owner terminates the project. You know, the projects may not make sense when prices get too high. So the owner may not go forward with the project, or may halfway through decide they want to stop it. And then the GC turns around and terminates you, even though you haven't caused any problems and you're not in default. So in the event that you're terminated for convenience, do you have any special remedies? Typically, under termination for convenience, you should have greater remedies. You should get paid more, be due more, certainly than if you were terminated for cause. But that's based on the contract language. So just look at your remedies that are available on termination for convenience. If you are stuck in a fixed price contract and you don't have an escalation clause or an escape clause, are there other creative ways to find some relief? Maybe. It's going to depend on the language of your contract, but maybe we can look at your unanticipated or unforeseen conditions clause. And if you look at the underlying reason for the price escalation, can we tie that into one of the reasons within unforeseen conditions doctrine? It was something that you did not anticipate and could not have reasonably foreseen that cause happening, and because of that cause, prices have increased. Therefore, you should not be at risk. You should not be responsible for the price increase. If we're going to travel down that road, make sure you provide timely notice. Most unforeseen conditions provisions require timely notice, written notice most often. So be on the lookout for that. Another creative option could be your force majeure provision, and we'll talk about that a little bit later in this presentation. But the analysis would be the same. Is the underlying reason for the price increase one of the reasons or events that's written out, set forth in your force majeure clause? And again, if you're going to go down that route as your escape hatch, make sure you're providing timely notice. So here is an example of the price escalation clause that we talked about. And this one includes a trigger. This trigger is a percentage. So fill in the blank, what percentage increase, above which you're not willing to bear the cost of the price increase. If your price is increased by 30%, if your cost increased by 30%, then you should be allowed to pass on the additional to the GC. I will say that even with this example language, it's still a bit vague. When it comes time to prove the percentage, to prove the trigger, how are you going to do that? How are you going to show the amount of increase in your costs? Because quite often you're not working on an open book. Your proposal may not have details of your material costs, so you don't have a starting point to compare to the increased costs. So that's just something to think about if you're going to go this route. And there is a trap for the unwary if you're going to do an escalation clause like this. If you limit it to a specific type of material within your scope, then you're excluding all other materials. So if you suffer an increase in a material type that is not identified in your provision, you're out of luck. If you limit your provision to a specific material type. So I suggest that you leave it, if you can, broad for all of your materials and all of your labor if you can. Our next topic is delay, and this is an important topic, and there's a lot of ways to deal with it in your subcontract. It's so much so that we could spend an hour talking about it, and in fact we have. We've done a presentation on delay targeted to subcontractors, And I would suggest that if you want to learn more about how to deal with delay in your subcontracts, you check that out. So we're only going to deal real briefly now with delay. Just point out some of the topics that fit within delay that you need to be on the lookout for in addressing your subcontracts. And those are, on the screen. No damages for delay or limitation of damages for delay, actual or liquidated damages. And I want to stop there for a second, because I know by talking with people in the construction industry, the term liquidated damages has a really bad rap. And I see subs have an automatic knee-jerk reaction when they see the words liquidated damages. Well, it's not necessarily a bad thing. And we can talk about that offline if you want, but there's a way to use liquidated damages as your friend, because if there is no liquidated damages provision, then you are most likely responsible for what's called actual damages. And that's who knows what those are going to be, but it could be a lot more than the liquidated damages amount. Another topic that you want to consider is when and how you get entitlement to extra time. That should be spelled out. And then, again, and last on the screen is force majeure, which is a timely topic. So we're going to talk a little bit more about that now. At a high level, what is force majeure? It excuses performance of the contract because of superior forces that are outside your control. Typically you hear acts of God, but then you also see things like war, hurricanes, fires, floods, government actions. These are things that are unforeseeable and outside of your control. Therefore, why should you be held responsible? You should be allowed to, at a minimum, suspend performance, get a time extension, not be responsible for delay damages. That's just at a minimum. But think through whether in addition to just waiving your liability, should you also be entitled to recover time and money that you suffer because of that force majeure event. Here's an example, and this is a rather broad and all-encompassing and I'd say favorable to a subcontractor. But before we dig into it, just the way courts look at force majeure clauses, I think that's important for you to understand, is they interpret them narrowly. That means they're not going to read a lot into it. They're not going to try to imply types of events that aren't spelled out in the provision. So, what does that mean to you? You do want to list out as many specific events as you can. Here we got a pretty long list, and relevant to the COVID pandemic era that we just went through. We specifically say epidemics, pandemics, but we also say government orders. So we're trying to head off those issues that we saw last year in as many specific ways as we can, but then we conclude the language with the broad catch-all of any other circumstance beyond subcontractors' reasonable control. And that gives you an argument that something not listed here should get put on the list. Should be a basis for you to use the force majeure clause in your favor. I also point out that this language includes a waiver of performance, also a waiver of damage. I think I think it's better to spell out both. Not only can you stop performance because of one of these events, but any damages that arise due to your halted performance that you're not responsible for. And then you take it one step further, and you will become entitled to an adjustment. You'll be entitled to time and money that you suffer because of these events. Now, that may be a stretch when it comes to negotiating with the GC, but something to try if you think you can. All right, claims for additional time and money, like delay, a very important topic, but one where there's a lot of things you can do in a contract. There's a lot of ways to address this topic in a contract, but we're only going to gloss over it here because we spent an hour talking about it on a prior webinar, and I'd suggest that you take some time and review that webinar because this webinar in particular has a lot of practice pointers, a lot of ways for you to mitigate your risk and protect your bottom line during the project. So I would definitely check it out. But just real fast, what is a claim? A claim is when anyone asks for additional time or money. That could be you asking the GC for additional time and money. Could be a change order, could be a delay, could be a back charge. Any of these, anytime you're asking for additional time or money, or someone making a claim against you. A sub, the GC coming after you saying that you delayed the project, or coming after you for a back charge that you harmed another subcontractor. So that's what a claim is. And I make a point to tell you that because you see the word claim used in a lot of contracts, and I find that some folks don't really get what that means, and so they gloss over it when they're reading some of the requirements. And those requirements are important because courts enforce them, as we explained in the other webinar. But look for in your contract claim notice provisions, timing provisions. How long do you have to make a claim? The procedures. Who do you have to make the claim to? Is it in writing? Is verbal okay? What's the form? What substance do you have to put in the claim notice? Do you have to explain how much cost and time is going to be incurred? All these things, again, spelled out in detail in the other webinar that we're referring you to. Next topic is termination and suspension. If there's no, let's start here. If there's no termination provision, well, if you as a sub don't have a provision allowing you to terminate the contract, then the law says, at least here in Florida, that you may only terminate for what's called a material breach. So that means it can't be any breach, it has to be material. Important to know that if you breach improperly, if you think it's a material breach, so you terminate, but the court determines that it's not, what does that mean to you? That means that the general contractor is going to have a claim, a cause of action against you for improper termination, and whatever damages they suffered from your termination, you're going to be liable for. So here, an example from case law I think is warranted. And this is a case in Florida, and it says that a contract required a written notice of breach and opportunity to cure. The owner gave a written termination letter. So this is talking about a prime contract where the owner terminated the GC, but it's going to be applicable to you terminating as well. The owner gave a written termination letter, but failed to give a written notice of breach and opportunity to cure. So the contract required opportunity to cure, the owner didn't give that. And the evidence was that the owner made several phone calls prior to giving the written termination. So while there were phone calls putting the GC on notice, the contract required that notice to be in writing. And the trial court found that the phone calls were substantial compliance with the notice of breach and opportunity to cure provision. That's the trial court. It went on appeal. The appellate court reversed and held that the clause that required written notice and opportunity to cure was clear and was not performed. So what does this mean to you? You have to strictly comply with your contract, especially with your termination provisions. And if there's a notice and opportunity to cure, make sure you follow that to the T. We're also asked by subs, my subcontract doesn't include a termination provision. It doesn't allow me to terminate, and I haven't been paid. What do I do? Well, when non-payment occurs, the extent and the effect of the non-payment must be assessed. So generally, non-payment is a breach of contract and a material breach of contract. However, the extent of non-payment will determine whether the breach is a material breach, which would justify termination, or it could be an insignificant breach, which would not be a basis for termination. If the non-payment is a small sum that doesn't affect your ability to finish the project, then it would be not a basis for you to terminate. So in sum, what does that mean to you? If you haven't been paid, if that non-payment threatens your ability or makes it impossible for you to continue to afford to do the project, then it's a material breach, and you should have a basis for termination. So let's now look at what do you want in your subcontract, and understand that it's hard to negotiate against these GCs, and you may not be able to get everything you want, but it's good to know what do you want. Well, there's two parts to termination. One is the GC's ability to terminate you, and the other is your ability to terminate. And so for the GC to terminate you, if it's termination for convenience, you want the GC to have to pay you your anticipated overhead and profit. And that's the remedy that you see discussed often with termination for convenience. And that's, you dedicated your team to this project, you missed out on other projects, and you should at least get your profit, total profit. For cause termination, you want the GC to have to give you written notice and a lengthy opportunity to cure. You don't want the GC to be able to terminate you for cause without you having the ability to correct whatever the GC says you did wrong. And you don't want the GC to be able to withhold payment due to you. You want all monies for work that you performed to be payable upon your termination. Now, the flip side, your ability to terminate. Of course, you want the ability to terminate for convenience, but that's not very common. But we talked about some reasons why you would in today's market, like an escape clause for skyrocketing prices. So that is something to think about now. Your ability to terminate for cause. If the GC or someone else is causing you detriment on the project, you would want to be able to give verbal notice of that. You don't want to be stuck with written notice, and you don't want to be required to give a long opportunity to cure. The last thing I'll say about termination before I turn it over to my partner Ryan is this is on the screen the AIA subcontract language, the A401 2017, and it's reasonably fair to subcontractors, more fair than the termination provisions we see in general contractors forms. So try to use this if you can. But so what does it say real quick? You have the same bases to terminate as the general contractor does with the owner. So that's, you're on a level playing field with the GC. That makes sense. That's fair. What else does it say? It says if you're not paid for 60 days, that's a basis to terminate. Okay, that's not bad. And if, in the event of termination, what can you recover? Of course, for work executed, so they can't withhold payment, and reasonable overhead and profit on work not executed. So if you're terminating for cause and it's not your fault, you're entitled to reasonable overhead and profit on work not executed. So that's where you want to be. And I will now turn it over to Ryan Maloney.
Good afternoon, everyone. Thanks for joining us. We're going to talk first about the indemnity provisions that you see in your subcontracts. And what is an indemnity provision? It's really a risk shifting mechanism. It's basically a clause that transfers risk from one party to another by requiring one party, the subcontractor, to assume responsibility for third-party claims made against another party, typically the general contractor, the owner, and sometimes the architect, under certain circumstances. You're going to see this in almost every subcontract, and so as we're going to talk about, the idea here is it's unlikely you're going to get it out. It's about limiting its scope and then making sure it aligns with your insurance coverage. So duty to defend versus duty to indemnify. Those are two different concepts. Often they come together in the same clause. The duty to indemnify, which we just talked about, arises once the indemnified party has to actually pay damages, and they can look to you to pay those damages back to them. The duty to defend arises much earlier, and that can arise as soon as a party that you're indemnifying and defending is sued. They can then tender that lawsuit to you, and you're required under the duty to defend the lawsuit for them, either by hiring an attorney to defend it or by paying for their attorney who they hire to defend it and paying the legal fees for that. So you often see these together, but they're two separate concepts. Recommendation, try to always get rid of the duty to defend if you can, and not have both that and the duty to indemnify. We'll talk briefly about Florida limits on indemnification. Florida, like many states, has an anti-indemnification statute. Florida's is construction specific. Other states may be broader, but there are often statutory limits on what parties can do in their indemnification clauses in their contracts. And then insurance, we'll talk about this, but really the concept here you need to understand is that the insurance and indemnity, they have to go hand in hand. And it's critical that you work with your broker to make sure that whatever indemnity obligation you take on in your subcontract is covered under your insurance policy. Next slide, please. Oh, yeah. So these are kind of the things that you need to focus on when you're looking at an indemnity clause in your subcontract. And the first one is you really need to make sure, again, it's going to be hard to get the indemnity obligation out altogether. So as a practical matter, what you need to focus on is trying to make sure that the clause is limited to an obligation to indemnify against third-party claims for personal injury and property damage caused by your own negligence and limited to your percentage of fault. What you really want to avoid is what's called a broad form indemnity, and that's where you can be obligated to indemnify the general contractor, owner, architect, whoever the indemnified parties are, for not only damages or claims caused by your negligence, but also for damages or claims caused by their own negligence. So it really not a great thing, and often some states will have anti-indemnity statutes that will address this. Florida does have such a statute, but the way the Florida statute works, which is Florida Statute 725.06, is the Florida statute says that those kind of broad form provisions in a construction contract are unenforceable unless they meet certain requirements. And the requirements are that the contract has to have a monetary cap on the indemnity obligation. That cap has to bear a reasonable relationship, commercial relationship to the contract work. And the cap has to be part of the bid documents and specifications. But if the indemnification provision meets those requirements, you can be, as a subcontractor, required to indemnify an indemnified party for their own negligence. So again, you really want to focus on keeping that out. If you see those kind of references to 725.06, that should be a red flag for you to try to get that out. Talk with the lawyer about how to limit that obligation in the indemnity provision. And then, as we discussed, and this is really, really critical, is make sure whatever you end up agreeing to as far as indemnity, you have to show that to your insurance broker and make sure that you have insurance coverage in place to cover that indemnity obligation. Typically, that's referred to as contractual liability coverage, but what you really don't want to have is an uninsured indemnity obligation, because that indemnity can last for a long time, even after the project's completed, and a claim could be asserted against you, even years down the road. And if you don't have insurance coverage, it could be potentially disastrous depending on the size of the claim. So the next section I want to talk about is limitations of damages. And really what I want to focus on here is provisions in contracts that waive or limit consequential damages. And what are consequential damages? Those are losses or injuries that a party suffers after a breach of the contract that are not the standard type that would almost always flow directly and immediately from the breach, but they're things that occur as a consequence of the breach in that particular case, and they are recoverable under the law as long as they were within the contemplation of the parties. So these the slide here lists examples of those types of consequential damages. And those could include, lost profits, lost rents, loss of use, damage to reputation, interest and finance charges. As you can see, a lot of these items could be particularly onerous in an owner situation where an owner, for example, an owner is you're working on an apartment complex job, and the job is supposed to be done by a certain time period, and it doesn't get done because you're delaying the project, and the owner's unable to rent out the apartments. Well, the money that the owner would have made for those days or months or however long, however late the job is, those are lost profits that can be part of the consequential damages. And that can be, as you can see, that could be really big numbers. And it can be very unpredictable and very large damages potentially that can have really disastrous potential consequences on you as a subcontractor if you're the cause of those damages. There's a case I do want to talk about briefly. This is not a Florida case, but it happened out in New Jersey, and it was the Perini versus Great Bay Hotel and Casino case. And this was a New Jersey case where Perini was a construction manager on a $16.8 million hotel renovation project. And the project was at the New Jersey Sands Hotel and Casino. And Perini's total fee on this project was $600,000. They were late. It went into arbitration, and the arbitrator ultimately awarded the owner over $14.5 million in consequential lost profit damages incurred by the owner because the facility didn't open in time for the summer casino season. So that's $14.5 million damages on a project where Perini earned a $600,000 fee. So as you can see, that's just the typical, a really bad example of how this could really, really go bad. In this case, this Perini case is actually what led the AIA to start including consequential damages waivers in all the standard, A201 general conditions, the standard AIA subcontract. And it's a great example of why those types of damage waiver provisions are so important. So here's an example of a consequential damages waiver, and this is the one that's straight out of the standard AIA form subcontract. And as for all the reasons we talked about, you need to make every effort to make sure that a waiver like this is included in your subcontract. And if you can't get a waiver, at a minimum, you want to try to negotiate some kind of cap on the exposure for consequential damages, so you don't get a runaway exposure that could potentially, really swamp your company. most of these waivers are going to be mutual waivers, meaning, you as a subcontractor are also going to have to waive consequential damages against the general contractor. But, when you compare the potential types of consequential damages that a subcontractor might have on a job, such as lost profits on other projects or additional financing charges, those type of things, typically those are going to pale in comparison to the potential consequential damages that an owner is going to have that they're going to pass down to a GC that's going to pass it down to you if you're at fault. And so typically, as a subcontractor, I wouldn't say for every time, but 99% of the time, you're better off having a mutual consequential damages waiver than allowing this potential exposure in your subcontract. And this, just one second, that waiver that we're looking at on the screen, that has been held to be an enforceable waiver of consequential damages by the courts. So this kind of language is something you could look to and use. Next slide. So the next section I want to talk about in the contract provisions are the insurance provisions. And typically, as a subcontractor, what you're going to have is the owner is going to require some level of insurance. Oftentimes, the prime contract will require the GC to require their subcontractors to have certain levels of insurance. So oftentimes it's going to be a flow down requirement that's going to be in your subcontract. And really here, there's two aspects to this that I think are most important. And the most important thing really is for you as a subcontractor to get those requirements, get with your insurance broker, and make sure that you can obtain the appropriate insurance to meet the requirements. If the requirements are lower than you might need, well, great, you've got them met and you're covered. If the requirements are more difficult or something that you can't get coverage for out in the market, well, you have to bring that to the attention of the general contractor, because if you can't get the insurance, the contract has to be adjusted to reflect what you actually can get, because otherwise, if you don't get the insurance required by the contract, you're going to be in breach of the contract, from day one. And it's also really important, I think, for you to understand and work with your broker to understand that you have sufficient coverage to protect your risk. This ties back again with the indemnity obligations and other potential risks. You want to try to limit that exposure through an insurance program as much as you can. And one of the important things is make sure you review with your broker or your insurance professional the exclusions in your policy. These policies have a lot of exclusions sometimes, and I've seen instances. For example, I had a client once that was a general contractor, and he was building a condominium project, and he ended up getting sued for some construction defects arising out of that. And we went to look at the policies that he had in place, his commercial general liability policies, and this was before I was involved, thankfully, and his policies had a multifamily construction exclusion. So the policies were essentially useless to defend against these claims. So you really want to make sure, and if you're doing stucco work, make sure you don't have a stucco exclusion in your policy. Just those kind of things, they seem obvious, but those exclusions can be very, I don't know if the right word is maybe not tricky, but they can be very complex, and so it's definitely something you want to review with your broker, or at a minimum, with your construction attorney. And then briefly, I want to talk about dispute resolution. This is going to set out the requirements for what you have to do. Make sure you comply with the notice requirements before you bring a claim. You don't want to get stuck down the road where you've missed a step and now you're stuck with your claim being defeated. A lot of contracts will have other requirements like pre-suit mediation. They can seem like hoops you don't want to have to jump through, but oftentimes that can help you resolve things and avoid costly litigation or arbitration. And then, whether the dispute mechanism is arbitration or litigation is often not your choice. It's going to be flowed down to you. There's pros and cons for litigation or arbitration, but, from your perspective, you just want to make sure that you understand what the requirements are and where you have to go to assert the claims. And then finally, just briefly, we'll talk about attorney's fees. The number one thing to understand about attorney's fees is they're not automatic, even if you win your case. only if there's a statute or that provides for attorney's fees recovery, or if your subcontract provides for it. So the lien law, if you have a lien claim, you have a claim for attorney's fees if you're the prevailing party. But if you have another type of claim, maybe you missed your lien deadline, or there's some other claim doesn't involve the lien law or a bond claim, then you won't have a right to recover your attorney's fees unless you have a provision in your subcontract that gives you that right. And just to the last slide, this is an example of a very broad attorney's fee provision. And you want to make sure that you have a broad provision like this. This provision covers not only the attorney's fees that you incur in the actual litigation itself, but also covers attorney's fees you incur post-litigation. Oftentimes, even after a trial, there's things that have to be, you have to show your entitlement to fees, and then you have to have litigation about whether the amount of the fees that you're claiming are reasonable. And those aren't normally recoverable unless they say specifically in your contract that they are recoverable. And this type of provision covers that. This also covers fees for appeals, for bankruptcy, and then even for post-judgment collection. And the idea here is, with this kind of broad provision, you want to be made whole. And by being made whole, if you prevail, not only do you recover the damages that you incurred, but you recover the costs back that you had to pay, for attorney's fees to get you to the finish line. So that's the idea of this type of broad provision.
All right, great. Thank you, everyone. I know that we've reached the end of the hour, but if you would like to stay for a little bit longer, we did receive a couple of questions, so we want to be sure to at least get through a few of those. The first one is, if a subcontractor has a claim that is based on actions by the owner, should the subcontractor enter into a pass-through agreement with the contractor?
I'll take that one, Elizabeth. So that's a good question. I would say in general, I would recommend doing a pass-through agreement, because you can lay out in the agreement the terms of the important terms of who's going to be responsible for prosecuting the claim. It make sure you have the obligation for the contractor to prosecute the claim with your assistance. Who has the right to settle the claim? You want to make sure that you have an ability to at least have approval rights on the settlement. And then how are the claim recoveries going to be split up and paid? Is the contractor entitled to overhead and profit on your claim? How are the expenses going to be deducted from any recovery? And then when will the the recovery be paid? Will it be once it's received by the contractor, or when the judgment is collected? So those are important aspects that I think, all in all, you should do a pass-through agreement. You just have to be very careful that you negotiate it to the best of your benefit to the extent you can.
Thank you, Ryan. As a reminder for anyone that is still with us, if you would like to submit a question, you are still able to do so on the upper right-hand corner of your screen. But for now, I'm going to go to the next one we received. This person asked, what do I do if I have a claim for extra work and am asked to sign a change order that includes release language through the date of that change order?
Elizabeth, I'll take that one. That's an excellent question. You need to, again, going back to my part of the presentation, make sure you understand what the general contractor is asking you to do in connection with the change order. And to the extent that you have previously reserved claims for which you've not been paid for extra work, whatever it is, you're going to need to have a discussion with the general contractor to avoid any argument that those prior claims are not released. And if it's an annotation to the change order or some sort of addendum, there needs to be some reflection that you are not waiving those prior claims. It is only the extra work that you're dealing with to add an additional window that you're dealing with. You're going to get paid for that, but everything else remains status quo. So again, make sure you read it. Make sure that if there are claims that you have previously reserved, talk with your team, make sure there aren't any claims that you haven't yet noticed or documented, to avoid any argument that once you sign that change order that all those prior claims or the existing claims other than the extra work that you're dealing with on that particular issue are still in play.
Thank you, Joby. The last question is also about changes, but I'll go ahead. It says, most of the GCs that I work with have their own subcontract and do not accept any changes to it. Do you have any suggestions for dealing with that type of situation?
Hey, Elizabeth, it's Austin. I'll take that one. And that really hits the nail on the head, because subs are often confronted with GCs taking that hardline position with their own form. So what do you do? Yeah, I'd suggest there's three things to consider. First, assess the risk to determine if you want to take the job in the first place. You know, Ryan gave an example about the Perini case. You know, is a $600,000 profit enough to take on a $14 million risk? So how do you assess the risk? Well, you look at the contract terms, of course. You know, does it have broad form indemnity that makes you the insurance company of the general contractor? You know, does it have waiver of consequential damages? But you can also go outside of the contract terms and you look at who the owner is. You know, do you know the owner? Do you know the general contractor? Do you know the product type? You know, the type of building or project? Do you know the geographic region? Do you know the other subs? You know, and if you know all of these folks and you've worked with them and you're comfortable, then maybe your risk is more manageable. Another thing to consider is, even though the GC may at first say he's not going to accept any changes, try pushing back. Terms of the contractor are just as important as your price and scope. And we've seen subs have success pushing back against GCs that at first said, it's my form or the highway. And if you do, just, you know, pick the 3 or 4 key terms that are the most important for you and see if you can get those more favorable to you. And then last, you know, you find yourself stuck with the GC's contract terms, you can at least minimize your risk by, you know, reading your subcontract, identifying what those key risks are in the terms, and make what I call a cheat sheet. You know, you've got, maybe it's just a 1-pager of all the key things your team needs to know about the contract, and you educate your team on that. And every day out in the field and in the office, you're making sure you're compliant with that cheat sheet to mitigate your risk. You know, you're providing timely claim notice. You're getting change order authorization from the right person. You know, those are some examples that can mitigate your risk, protect your bottom line. You know, and that's it.
Great. Thank you, Austin, and thank you, Joby and Ryan. We appreciate everyone joining us today and tuning into our webinar. That is going to close our Q&A for now, but if there were any questions that we could not get to that you would like to address with any of our presenters, their contact information is available on our website if you would like to connect directly. That website is jimersonfirm.com. As always, if you have any feedback on today's presentation, please feel free to send it to us via the link that you will receive as a follow-up to this event. This follow-up email will also include a link to the recording of today's presentation. Again, we appreciate you joining us and hope you have a great rest of your day.